reasonable people may differ.
Right. And Your Honor, the court is exactly right when the court states that I think when Mr. Kendrick, if you watch that video, Mr. Kendrick is getting more and more wound up.
I noticed that. I noticed that.
Interrogation, and he's done. He's had it with a lot of them. Now, just because they let him cool off for 45 minutes and eat a sandwich for lunch, that doesn't cure that. That doesn't mean they can come back in and immediately start interrogating him about Kendra Morton, which is what they do.
All right. Folks, here's what I'm going to do. I'm going to take, I've got something I have to take up now, unrelated to y'all's matter. Let's just take something. I believe lunch may be here. Is that? All right. I'm going to go ahead and let you all eat lunch as our jurors will be back shortly. So let's go ahead and come back for 1 o'clock, and I'll see if I can make a decision. I got to take up a couple other things with you as well, and account for our jurors.
Okay, and we also, Your Honor, have, of course, to take the floor. The state would like to play the remaining portions of the video that we.
I don't need them. I don't need them. I really don't. I think this is the crux issue you've all have identified for me. I really don't need the rest of. I'll admit states 1, Kendrick motion 1, and states 2 for the video statements, but this would be whether or not it's an equivocation. I'll accept what you told me, Ms. Love, about the other circumstances involving this particular statement. But And
Your Honor, as Mr. Weinstein just said that he was done and all of that, I think it's important that the court see his demeanor and the context of the conversations that took place prior to Detective Golphin, and
that doesn't make it. It doesn't. Once you're trying to parse this out, Ms. Love, and you're doing your job. But here's the problem. An equivocal statement stops interrogation. That's what it does. We don't get to look behind it. Well, did you really mean it? Did you kind of sort of want to do it? I mean, the Supreme Court's been very clear with us, both the United States Supreme Court as well as our Supreme Court, in telling us, if you make an equivocal statement, that questioning must stop. And like I said, Ms. Love, I think the problem or challenge you all are having in this particular circumstance is your third-party detective really he inserted himself in something and caused the defendant to invoke his right or basically terminate the interview and say, hey, I want to talk to a lawyer. So at that point in time, he's for a lack of a better word, he has messed up. That's the kind word of a way of putting it. He's messed up the interrogation at that point.
And Your Honor, just so I'm crystal clear with the court, we're not only asking for that October 6th interrogation to be suppressed, but also the following on the 12th. Because let me please just finish. And then I'll let you talk, I promise. Because Mr. Kendrick did not initiate that October 12th. He was brought to that room for the interrogation. So there's been no initiation by Mr. Kendrick on the 6th. He did not initiate that conversation on the 12th. Once he invoked his right, as this court points out, it's done.
If I decide that, yeah.
Thank you.
We don't have evidence, but we do. We have actually a witness. Mr. Weinstein's statements as to who did what on the 12th is not evidence, and we do have a witness to present that to the court.
Well, that would be an independent basis. So, right? Is that what you're telling me?
Yes, I'm telling you that, yes, Mr. Weinstein is asserting a thing, but we would put up evidence as it relates to.
Well, as long as it's not attributed to the defendant's statement, if I decide that, then of course I'd look at it independently. Of course, that would be the rule. All right, let me come back at 1 o'clock, and I'll talk with you all a little bit more at that point in time. Okay? We're in recess until then.
Mr. Weinstein, do we have the site that she quoted, your case law?
Okay, yeah, I'm sorry.
before you off. I ain't APD out there. They was on the outside. You can scratch the APD tag.
Oh, wow. And here it is. And then Mr. Chamberlain should have provided you a mechanism from for the Georgia Department of Corrections to email the appropriate parties. I'll make that exhibit as a next court exhibit in order. So it'll be your responsibility to take care of that, okay? All right. Okay. That goes to state, and this goes to Christina. that goes, the instruction sheet goes to Christine. So that's the next court exhibit. Okay, I've had an opportunity to take a look at the, and consider the motion to suppress statements of defendant DeMontre Kendrick, and also to take a look at the state's response in respect to those particular assertions in terms of the for Jackson Daniel hearing, which the court has to make those determinations of voluntariness thereof. What was the last thing you heard, Christina?
Application in terms of the Jackson Daniel hearing, which
The court has to take into account to determine the voluntariness of statement. In such, I have considered as well and will be admitted for purposes of the motion to suppress Jackson Daniel hearing states 1 and 2, Mr. Kendrick's video statements. In particular, the court has viewed a portion of those particular statements relative to the periods of time at 2:16 p.m. continuing for approximately 3 minutes or thereabouts. Also from 2:56 p.m. continuing to about 2 or 3 minutes. And the court specifically has heard in the first video at 2:16 or thereabouts, near the end of that colloquy with the detectives, I need to talk to my lawyer. I don't want to talk no more. And at the second video, starts at 2:56 p.m., goes for about 2 to 3 minutes or thereabouts, and stops at 2:58 and 53 seconds.
Your Honor, may I address the court?
No, I want to make my ruling, okay?
I haven't presented any evidence.
I can take this on argument, and that's what I'm going to do. I'm going to, in terms of the what's been admitted for the court's consideration, that particular portion of the video is what I need to focus on. What I need to focus on is whether or not Mr. Kendrick was in custody, whether or not Miranda was appropriate at that point in time, and whether or not he invoked his right to counsel.
And whether he reinitiated it.
Yes.
We have the officer to talk about that.
I don't need that at this point in time. I really don't. I'm of the opinion. I also had a chance to take a look at Mr. Uhelski sent me as well, and I'm sure the other counsel got a copy of the United States versus Kendrick, both the district court order, which was a hearing in front of Judge Alan Baberman, the United States magistrate, and then Judge Mark Cohen, United States District Court judge. And then the appellate opinion was an opinion based on sentencing. Mr. Kendrick appealed the severity of his sentence. So I'm taking a look at the appellate order, at the trial court order from Judge Cohen, adopting Judge Baberman's findings.
Right.
And I make it very, of page
2.
During the course of page two, during the course of over 2 hours of the initial interview, defendant did not ask to speak to an attorney. At some point during the interview, Detective Joe Galpin, who was investigating a separate homicide incident, entered the room. Defendant then indicated he wanted to talk with his attorney, and questioning stopped. So Judge Baberman, I can't tell whether or not he took into account what I heard on the video, which was, I need to talk to my lawyer. I don't want to talk no more. That is equivocal to this court, me, Judge Glanville, that he invoked his or withdrew his consent at that point in time and did not wish to speak to law enforcement officers anymore. I understand the state's argument about parsing it out, asking for clarification, but I think that once he's, the appellate, case law that I've looked at, in Paul Doe and others, he has invoked his right at that point in time, and it's this court's opinion that anything thereafter would be inadmissible.
Your Honor, the court also found that he reinitiated, and that was what.
But that's their issue. That's not my issue.
Your Honor, I'm not.
Okay, and to your point earlier, Judge Cohen and Judge Baberman, I can't tell whether or not they listened to what I heard, but you're only as good as the information that you're given.
Right.
So it doesn't say on this particular order that that's what they relied upon. It just says he wished to talk, some point in time, he wanted to speak to his attorney. Now, I'm of the opinion, this court's of the opinion that questioning needs to stop. He's unequivocally revoked. And you can't pick and choose at this point in time whether or not it's to this particular crime or any other assertion. So that's why I'm going to suppress it.
And Your Honor, Your Honor, with respect to the statements that were made after that time, we do have, as I stated, Investigator Thorpe to tell the court on the record, present under oath, that it was not Detective Thorpe, it was the defendant that reinitiated the conversation with Detective Thorpe. Our representations to the court are not evidence, and since the state has the burden of proof.
Okay, but I've seen the video at this point in time.
Video does not encompass when the defendant actually reinitiated contact.
But the problem is, he invokes, and then we don't know what goes on in the 45 minutes, but we come back afterwards, and at that point in time, you don't get to eat your cake, have your cake and eat it too. It's once he invokes, that's it. It's over.
Your Honor,
They should not be bringing him back at that point in time and asking, well, let me just clarify a little bit about whether or not these statements were made to these set of detectives or to Galpin.
It wasn't there in the room that I'm talking about, Your Honor. I'm talking about in the first, the defendant asked for a smoke. So they took him out for a smoke. When they took him out for a smoke, the defendant reinitiated the conversation as they went outside. That is what they found in the district court, but the court doesn't owe that deference. That is why we have, as the burden of proof, holding the burden of proof, that is the reason we have Detective Thorpe here to testify.
I don't need his, I'll consider it, but it's this court's opinion that once he invokes, you don't get another bite of the apple by taking him outside, softening him up, giving him a cigarette, some bonbons or whatever, and then letting him go ahead and then say, oh, well, let me just clarify with you a little bit. That's not how that this scenario worked. I think that you all are just annoyed more so that your detective did something that he probably regrets now. And that you all probably would not have told him to do. Don't interrupt this particular investigation or this particular hearing, because what you did is you just now created a wrinkle that now I got to deal with, or whether or not the defendant has invoked his right to counsel. He has.
And Your Honor, I'm not annoyed, Your Honor. I just have, with the burden of proof, we have a person who can speak to the issue rather than having us, sort of speculate as to what happened, because it's not, as the court at this time has indicated that it sees, which is that we softened him up with things.
That's my ruling. And prepare an order suitable in my directives.
Yes, Your Honor. Thank you.
Mr.
Your Honor, we have not presented any evidence regarding what happened in the Sally court. Would the court permit the state to present evidence of what happened when they went upon the defendant's request to get a cigarette?
Ms. Love, I'm of the opinion it's not going to change my mind at this point in time, in terms of, because he's invoked, anything after that would be improper. It really would be, because it'd be one thing if he said, well, maybe should I get a lawyer? Maybe should I do whatever this, or, kind of vacillate. but he's pretty significant in the sense of, I need to talk to my lawyer. I don't want to talk to no one.
And Your Honor, our case law shows that even when that happens, when the defendant reinitiates the conversation and communication, that the court has found that those statements made after the defendant reinitiates conversation, as unequivocal as his initial assertion was, when the defendant reinitiates the conversation, the statements that he makes are not to be suppressed. And in this case, the defendant reinitiated the conversation, not the officers. And Your Honor, we've provided to the court, and we have, of course, we have proof. We have actual testimony, given that we do have the burden of proof. Your Honor, Munn versus the state, 313, Georgia 716, says that the court must consider the totality of the circumstances and determine the admissibility of the evidence of the statement under the preponderance of the evidence standard. And Your Honor, given the fact that we have a witness here to testify, the court doesn't have to take my word for it or Mr. Weinstein's word for it. We have the person who was there. The court gets to gauge Detective Thorpe's credibility, and the court then has substantive information and evidence upon which to base a ruling under the actual totality of the circumstances. Right now, we have a clip. When I asked Mr. Weinstein to play for the court the portion to which he objected, that wasn't the state conceding that we weren't going to put up evidence, Your Honor. I was trying for the sake of brevity to have him point out the part that he objected to, but then that left us without the ability to present anything. And we weren't stopping there. We were just showing to the court where he was arguing the points that he made to us that he wanted to contest. So we would like to present actual evidence to show under a totality of the circumstances.
I got the evidence. It's been admitted. The two videotapes are sufficient for the court's analysis at this point in time. Sir, anything
That's
else?
your ruling. Thank you. I have nothing to add, Your Honor.
All right.
And Your Honor, what happened with the Sally Port, the conversation being reinitiated by the defendant, that actually happened, and we have the proof here to show it to the court.
Well, based upon what you've argued so far, and that in this particular circumstance, this court's of the opinion that it's like this. Once you initiate your right, or you revoke your right to be examined and have counsel and to have counsel present at that point in time, the courts are very, let's just say, cautious about reinitiation at that point in time. And you all presented to me what was the salient point of this particular issue is. So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop. You're not supposed to go out and get cigarettes and do everything else. It's supposed to stop. I mean, that's this court's opinion. So, and that's my ruling.
And Your Honor, the thing is that, Your Honor, we did not.
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Your Honor.
If you have other evidence independent of this, I'll consider it at the appropriate time.
And we do, and that is what I was asking. So if the court will permit me to actually introduce the evidence that we have, as the court in State versus Paldo 309 Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the state, 306 Georgia at 35. Your Honor, Edwards versus Arizona. And Your Honor, this is a 2020 Georgia Supreme Court case where it specifically says that a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available or until the suspect reinitiates the conversation.
Your Honor, at some point, Your Honor,
I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not stop.
Hey,
I was speaking.
Ms. Lowe,
I'm sorry, I was speaking.
Both y'all can't talk at the same time.
I know, I
Under the
was speaking, and I
state
expect
law,
to
wait,
be
wait,
allowed
wait,
to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
And I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that
Okay,
fact.
no,
but
you
Judge, we
don't.
have
No,
not-
you don't.
Your Honor, we have just not been able to present the evidence. That
No,
the-
you don't. I
state
get it.
has to
I
present.
get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
When the court says independent basis, does the court mean outside of that video? Because we do have that.
Yeah, if it's not tied to the statement, of course you can introduce it. I mean, as long as you have some independent basis, right? If you didn't get it from his particular statement.
But Your Honor, that's the point, that we have the witness here, that we brought the witness here, and had him cancel medical appointments to testify to the court about. We brought the witness here.
I
so
made a
we could-
ruling. That has nothing to do with it. That's a red herring and you know it.
No, Your Honor, I was saying that we were ready to present evidence and the court is not allowing us to present the evidence. That's all that I'm saying. We have the burden of proof and we haven't even been able to present the evidence that we have. We only, for the sake of ease, allowed the court to introduce the statements that the defendant made as states 1 and 2 to help Mr. Weinstein play the portion that he wanted to talk about. We didn't even get a chance to play or to have the evidence that the state has ready for presentation to the court to be presented. We should be entitled to present the evidence so that the court actually has the circumstances and does not have speculation or conjecture as to what happened when the Georgia Supreme Court has clearly said, just as clearly as an attorney being present is required before you consider the statement once he's invoked, the court has as clearly said, if he reinitiates, then that statement can be considered. It does not use them like maybe. It says, if this or that, then the statement can be considered, unless it should be suppressed for another reason. And that case, Paul Doe, is as recent as 4 years ago. And I'm not just doing this for the sake of engaging in a pattern of behavior, Your Honor. I am standing here emphatically asking that the court allow the state to present its evidence so that the court can make a ruling based on the evidence and not on the assertion by one party or the other as to what should or could be done. We have evidence that I believe that the state is entitled to present and the court is entitled to hear in the form of testimony. And I understand that Mr. Weinstein wants us to hurry it along and not hear Detective Thorpe because that might be an adverse position or evidence to his client's position. But we are simply asking that the court allow us the opportunity to present the evidence and to not hold it against the state that I am asking this, that the court allow us to present evidence that this statement was made voluntarily and that the fact that he ceased it but then reinitiated it is something that the court should consider. And Your Honor, I don't like drawing the court's ire. It's, quite disturbing, but I cannot in good faith not present evidence when we have a whole burden of proof to show the court that it was made freely and voluntarily. And when the evidence that we have is sitting right outside the courtroom. And the court's whole purpose for having these hearings is to determine the truth and to decide what is fair. And without hearing from Detective Thorpe, I don't know how the court can discern what the truth of the matter is, hearing only a portion of a recording and not hearing from the people who were actually standing there talking to and listening to the defendant. Unless without hearing Detective Thorpe, the court is making a credibility judgment before even hearing what he has to say.
May I please speak? Please, may I please speak?
Okay.
And Your Honor,
Are you finished, madam?
I was not, Your Honor. I was
Your Honor,
Hold up. You got 30 more seconds. Wrap it up.
And Your Honor, I'd ask again the court for the opportunities for the state to be able to present evidence so that the state can meet its burden and not have the court make any kind of ruling based on really partial pieces when the court does not have a totality of the circumstances as a part of the record for the court to consider. So I would ask the court in earnest to allow us to at least present the testimony of Detective Thorpe, if not today. I don't mind doing it. I said in my email to the court and to counsel that we can do this closer in time because he does have or did have that appointment closer in time to when this matter will be right. But Your Honor, I ask that I implore the court to allow us to actually present the evidence that we have to present. I appreciate Your Honor giving me the moment to speak. Thank you.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that opposing counsel can speak. Your rulings at some point have got to be final, Your Honor. Whether you hear from Detective Thorpe or not is irrelevant. He requested his lawyer. He invoked his right to not speak anymore. And I don't care what schmoozing Detective Thorpe did out at the Sally Port, taking my client off camera. I don't know what went on down there. I don't know what self-serving, well, I have some idea. I don't know what self-serving statement Detective Thorpe could possibly give to this court that would cause the court to change their order. This continued going back whenever the state loses in this case has got to stop at some point, Your Honor. Thank you.
Prosecutor asked the swear-tos that were conducted both for the charges made against him and the charges alleged against his son as well, the charge made against his son. Do you recall those questions?
I do.
And the prosecutor confirmed with you that the process for this swear-to is open to the public.
That's correct.
You said that both the public and the media were present at the swear-tos for both Mr. Crumbly's son and also Mr. Crumbly.
That's right.
For Mr. Crumbly's son, you made note that Mr. Crumbly was not present in person for the swear-to in the arraignment.
Yes, I stated he was he was there on Zoom.
And if you recall, his son was also on Zoom for the arraignment. Is that correct?
His son was in custody.
Okay.
All right, Mr. Love, and Mr. Weinstein, I've had an opportunity to consider. I'm gonna leave my original ruling as is, okay? So, Mr. Weinstein, if you would prepare a suitable order for my analysis, okay? Send that to Ms. Love and her colleagues, okay? All right.
Your Honor, we also have a matter of the issue that we addressed at the bench prior to leaving court the last time, the assumption of facts that had not been presented.
Yeah, in fact, thank you for reminding me of that. I was gonna ask you all, had you had an opportunity to determine whether or not Mr. Bean, in fact, was in custody, or not was he in custody or was he at some point in time at the hospital?
So, Your Honor, there are two things. One, Mr. Bean, I did determine where Mr. Bean was, and I also determined that there were no statements that were made by Mr. Bean. So, Mr. Bean,
Okay, so let me ask the question directly. Was Mr. Bean ever at Grady Hospital?
yes, he was at Grady Hospital. He was held in Grady detention by 2 officers after he was arrested by Officer Faust on the 2012 warrants. So he was arrested for a different incident that had nothing to do with this incident, and he was kept for that purpose. No one talked to him, no one interviewed him, no one interacted with him about this case and the facts of the 2013 incident at all. There's none of that. Mr. Steele told the court that he had a good faith basis for asking the questions that he did, when in fact, the questions that he asked assumed and in fact put in the jury's mind that there was evidence that does not exist. So at this point, the jury will be looking for a statement from the hospital when there was not one made. No one questioned Mr. Bean at the hospital about this incident.
So then how was he at Grady medical detention? Was that a different incident or was he actually at Grady?
He went to Grady detention. He was taken there by Officer Faust.
Okay, and is Grady detention at, or on the campus of Grady Hospital?
Yes, it is a part of Grady Hospital. And what Mr. Steele represented to the court was that Detective Velazquez testified that.
Hold on 1 second, please. All right. So we were talking about Mr. Bean, and there's a detention facility that's actually at Grady Hospital, correct?
There he is.
All right. Is that what Mr. Steele was referring to, or could it be that he's referring to that?
Your Honor, this is the issue that I have with what Mr. Steele is doing, and this is what 24-1-103 prohibits. Specifically, 24-1-103, as the court is aware, states that jury proceedings shall be conducted to the extent practicable so as to present inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof or asking questions in the hearing of the jury. So when the state has been making the objection that the questions Mr. Steele is putting upon the witness assumes facts that are not in evidence, Mr. Steele has responded by saying he has a good faith basis, but instead what
Well,
he
the
is
court
doing,
asked him that, and he can ask the question if he has a good faith basis, meaning that he cannot misrepresent or lie to the court about Mr. Bean's whereabouts. So I wanted to make sure that was kind of not occurring. So I understand what a 103 analysis or inquiry allows the court to do. So is it your opinion? I just want to ask you a question. Sorry to hijack you again. Is it your opinion that the conversation about Grady is not appropriate because it was at Grady detention or in the hospital?
No, my assertion is that Mr. Steele's questions go something like this. Why did you tell Detective Lewis at the hospital that you were not driving? He also
Is that
asked,
Grady detention though?
yes.
Okay.
But wait a minute, Your Honor. This is just it. His question, why did you do that, assumes that the witness did that. And there is no evidence that the witness did that.
It needs to be rephrased.
And Your Honor, he also 28 times has asked, when you talk to your wife on an unrecorded line at Grady Hospital, there's no evidence that he did that. There's no evidence that will come in, and there's no evidence that Mr. Steele can bring to the court. And if he does, I would ask that he proffer it, because I listened to the information, to the recording that Mr. Steele gave us at 6 o'clock that day that he presented, that he cross-examined Mr. Bean. And he asked a plethora of questions that are nowhere in that recording. And he is doing it on the basis that he is confronting him with his prior statements. But the problem that I have is this. In that recording, Mr. Steele references prior conversations that he has had with Mr. Bean. So in an effort to discern what he's talking about or what information Mr. Steele may have fed Mr. Bean or what happened, I asked the witness, who is also on the recording, I called him up and said, I'm trying to find out how many times you all talked to Mr. Bean, what did you say, and whether there were any other recordings. The witness, Mr. Steele's investigator, told me, I'm not comfortable talking to you without Mr. Steele. I won't talk to you without Mr. Steele. As a matter of fact, no, you may not call him while we're on the phone. I don't want to hang up on you, but I will. And this goes to privilege. I said, I'm just trying to discern how many times you all talked to Adrian Bean so that I can have information that I'm entitled to. He would not give me any information. So I called Mr. Steele. Mr. Steele didn't answer. So I wrote Mr. Steele asking for how many times you talked to Adrian Bean. Give me the other recordings. Give me what you have. He did not respond. I called Mr. Steele. I said, Mr. Steele, how many times did you talk to Adrian Bean? He tells me, I'm not going to answer that. What you're doing is somehow unethical, and we'll take it up with the court in the morning. I said, okay. So, Your Honor, the problem that I have is, one, Mr. Steele is improperly suggesting to the jury, planting in the jury's mind that this witness made certain statements to the police at the hospital when he did not. Mr. Steele doesn't have any evidence whatsoever, any statement. He doesn't have any recording. He doesn't have anything. He has not asked the witness. He has not done anything to present a statement at the hospital by this witness, and certainly not one to Detective Tracy Lewis. So Mr. Steele tells the court that his good faith basis for asking the questions that he is asking is that he is confronting the witness with the statements that he made during the recording that Mr. Steele provided the state on last Monday. When in fact, the information that he is asking, he is not saying, did you talk to Detective Lewis, or you talked to Detective Lewis, didn't you? Instead, he's saying, why, when you talked to Detective Lewis, did X, Y, and Z occur? And that in itself is exactly what this rule is designed to prevent, Your Honor. Because unlike asking the question, it's sort of like asking, did you mean to beat up your wife when you hit her in the head? When there's no evidence that the wife was hit in the head or that the person on the stand actually did it. So under 24-1-103, 24-6-6-11, 24-6-6-23, the state would ask that all of these impermissible questions be stricken and not allowed. So when he is asking these 28 times, why did you do this? Why did you do that? Unless and until he can show in his recording to the court where the witness told him those things that he is saying to the jury the witness said, then I would ask that the court prohibit him from referring to anything of the sort that did not occur.
Okay.
And I would ask that we can go back over it at a later time. For now, I would simply ask that the court prohibit Mr. Steele from presenting to the jury things that he knows aren't in evidence and will not come in evidence. And I would ask that the court require Mr. Steele to turn over to the state if he has some more recordings, or at least tell the court and the state how many times he's talked to the witness. Because in a state where we are not only providing to defense counsel unwritten statements that we have or unwritten conversations, we're providing them summaries of conversations. We're turning over at the court's direction information that they normally would not be entitled to. At the very least, if they talked to Adrian Bean a number of times, and to be clear, what Adrian Bean did in the interview with Mr. Steele, in my opinion, Mr. Steele's suggestion is recant and say things wholly favorable to Jeffrey Williams. And Mr. Steele, I guess, doesn't want it to look like he is, Mr. Bean is trying to favor his client. But I ask that the court listen to that 10-minute conversation that Mr. Steele had with Mr. Bean, and then the court will understand why the state is objecting to Mr. Steele's questions. Why did you do this when you gave your statement to the police at the hospital? He knows that Mr. Bean said in his interview with Detective Quinn, when I talked to the first guy, I said X. That was on scene. That was on scene. And Mr. Steele knows that. He knows there's no suggestion that that happened at a hospital. Mr. Bean was transported to the hospital. We have him with Detective Faust, who was there, who arrested him and took him to Fulton County Jail shortly after. The CAD report showed that he was transported to the hospital around 1, and he was taken back to the jail and booked in around 6 o'clock in the evening. And there is, Detective Quinn is still on site at the scene during that time. Detective Lewis, during that time, has gone and spoken only to, I believe it was, to Walter Murphy, only to Walter Murphy. She documented it. She documented what Walter Murphy said. Detective Calhoun went and spoke with Frederick Prothro, documented it, documented what he said.
So nobody had a conversation with Mr. Bean at Grady?
Correct. And if Mr. Steele wants to say that he did, it is his burden once the state has asked the court to determine that so that we can get this issue resolved. He has to show where this statement is. And to sit there and ask for something from the state that he knows there's no record it even exists is disingenuous at the least.
Okay. All right.
So I'm asking that the court disallow these questions that begin with, did you know that? Why, when you talked to so-and-so at the hospital, did you do this? Why did you, when you talked to your wife on an unrecorded line at the hospital, there's no such evidence, nothing like that. that even exists. It's fabricated evidence. He is trying to fabricate evidence to confuse and mislead the jury so that when the jury hears his question, they already have in his mind, oh, there's an interview at the hospital. Where is it? Why haven't we presented it? Why didn't the state present it? I have no doubt at the end they come up with this. The state didn't show you the interview at the hospital when one doesn't exist. So I would ask that Mr. Steele be required, one, to turn over any kind of information that he has to the contrary, provide to the state any conversations, any interviews he has done with Adrian Bean. I don't know what happened during those interviews, and I don't know what his investigator said to him. I don't know what was promised to Adrian Bean. We have no way to know that because neither Mr. Steele nor his investigator will divulge that information. And Mr. Steele has yet to show he's, one, improperly, again, putting untrue assertions in front of the jury with his questions, and two, has not provided the court anything to show that what he is suggesting to the jury actually exists.
Would they be required under the reciprocal discovery statute?
Well, in order to impeach a witness with an inconsistent statement, the party that is using the statement has the obligation to afford the attorney, the other side, to the opportunity to question the witness on those statements. So yes, we are supposed to have those statements and we don't have them. And the questions that Mr. Steele is putting on this witness go way outside of the boundaries of this 10-minute conversation, this clip of a recording that he has.
Okay, all right. I'll hear from Mr. Steele. All right, sir.
Good afternoon, Your Honor.
Good afternoon, sir.
Good afternoon, everyone.
Can I ask you the $64,000 question, Mr. Steele, to begin with?
Sure.
Is there an interview of Mr. Bean at the hospital or Grady detention facility?
Yes, that's what he told
Okay,
me.
can I see it?
That's what I've been asking for.
No. Do you have it?
That's what
Do you have one?
No, I've been asking for.
Well, okay. Here's our challenge. Unless you know there's one and the state's told you they don't have one, then you don't really have a good faith basis to ask that question.
Mr. Bean told me.
But now there's come to light that Mr. Bean he's at Grady. He's in Grady detention, but he hasn't made a statement to anybody else, any law enforcement officers.
Let me take you back because that's not the way I understand it.
Well, did he interview? Did he have discussions with Detective Faust or Detective Lewis at Grady?
I can't tell you which detective. I can tell you that is what he said, and it's backed up.
By whom?
I'm going to show you, if I may.
Your Honor, let me play the recording. It takes 10 minutes.
Of Mr. Steele's investigator?
Yes.
Sure, we can hear, but let me hear from Mr. Steele first.
Okay. So what happens here, Your Honor, is last time we were together on March 4th, 2024, the district attorney stopped the cross-examination, approached the bench, and the following occurred. This is an excerpt portion. I'll mark it as Mr. Williams, number.
First name is
Number B, dated today. And what happened is the state, just like it's doing now, accused me of the following. And this is just the context, and then it will get into exactly what you're asking. It's on page 2, Your Honor. District Attorney Love stated, starting at line 13, that I told the witness what to say, that Mr. Bean was never taken to Grady Hospital. From transfer page 2 to 3, District Attorney Love said, Mr. Bean was never interviewed at Grady Hospital. Transcript, page 3, lines 3 through 4, and 8 and 9. Mr. Bean went straight from the scene of his arrest to the Fulton County Jail. Page 3, line 18, when this honorable court asked the question, did he, meaning Mr. Bean, go to Grady? Ms. Love stated, and I quote, no, he, meaning Mr. Bean, did not go to Grady. Mr. Steele told you about whatever he's trying to do. You asked me, did he go to Grady? I said, that's what he's saying, or some hospital, yes. Page 3, line 18. 20 to 22. On page 4 through 5 of the same transcript, I asked.
I have the transcript.
Okay. I asked in lines, it's transcript 4 through 5. I asked for Mr. Bean's statements to police. And he said, this way I understand it, is Jeffrey Williams was not in the vehicle, or he didn't mention him in the vehicle. He put 3 people in the vehicle, and he lied about who was the driver of the vehicle. And I said, it's Brady evidence, I'm entitled to it. Transcript page 5, lines 20. Starting in line 20 through transcript page 6. District Attorney Love answered your question. Nothing shows that Mr. Bean went to the hospital. District Attorney Love on transcript page 5, line 24 through 25. Mr. Steele is misrepresenting that to the court, meaning that he was taken to the hospital. Transcript page 6, lines 1 through 5. District Attorney Love states Mr. Bean went straight to jail and that the district attorney has the documentation, the printout. I asked to see it. I was never shown it because I didn't believe it to be true. And I'm going to tell you why I believed it wasn't true. To answer your question fully. Transcript line 7, page 4 through 5. I have no good faith basis to ask this question. Ask this question is my words. Transcript page 7, lines 6 through 9. District Attorney Love said that I have nothing of either Detective Quinn saying on recording, hey, he went to the hospital. District Attorney Love stated to this honorable court, continuing to tell you that I misrepresented intentionally. Page 7, lines 10 through 24, that I assume things, nothing on the tape. Mr. Steele, this is a quote, put that in there, end quote. Mr. Steele knows it did not happen. Mr. Steele is manufacturing evidence. On page 10, you advised us on line 20 through 25, the issue is whether Mr. Bean was taken to the hospital, whether Mr. Bean made a statement at the hospital, and on transcript page 11, lines 9 through 10, District Attorney Love, again, Adrian Bean never went to the hospital. So I knew that that was all wrong. But, you know, when a lawyer says something like that, maybe my information is wrong. I'd like to see the documentation. I don't get anything. So, Your Honor, and it's in evidence. If it's not, I'd like to put it in evidence. The reason I believe that he went to the jail, not straight to the jail as being told to you, is that in discovery, the following occurs. And I'll mark this as Mr. Williams' exhibit number 202 with the court's permission. It can be played for the court. This is the file. It was given in discovery by the state of Georgia to Mr. Williams and all. This is the police radio traffic. You heard some of it during the trial through the witness who identified the radio traffic. It starts at 0054. This is Z radio, 1231 hours through 1300 hours, so 1231 through 1 o'clock. And it reads, down here on Cleveland Avenue, start us at 4. That means ambulance, Your Honor. You heard that through the testimony. For a 34-year-old black male with injuries to his shoulders, head, and to his back. If you remember, Mr. Bean was born 6/22/1979. That would make him 34 years old on September 11th, 2013. It says, okay, Cleveland Avenue, Old Hayfield, 122 Cleveland, and that ends at 112. At 1300, Major, where do you want me to bring the bus, meaning the ambulance? Oh, come up here to Cleveland and Old Hayfield, take a right. I'm standing here. I'll direct you in. That's at 1314. At 1602, 2308, I'm still at Cleveland Avenue, Old Hayfield. I got a perp in the backseat of my car. That's at 1607 it ends. At 2808, 2308, I'm right in the parking lot. Tell him to come down Cleveland Avenue. I'll get him. I'm in the parking lot of the Coin Laundry. All right. Trying to get Grady to find you. Right. Then it says unintelligible for my notes. I'll get out of the car and flag him down. That's at 2028. Then at Mr. Williams, I'll mark it exhibit number 203, Your Honor, for purposes of this, or I'll play it for the jury. File Z radio, it's 1301 hours through 1330. So that's 1:01 in the afternoon to 1:30 in the afternoon. Same date, September 11, 2013, 1842 on the recording. 13 radio, following Grady Unit 320 down to Grady Hospital, 1848. At 2736, are you en route with another victim? We en route with another suspect. The other suspect, okay, I copy that. He's 1050. Also, at 1050 is a shot. Says, I don't think so. He's going to be in custody. He's in 83. 83 means another warrant. Mr. Bean at that time had a warrant for the year before for shooting 2 people. You heard that impeachment. He pled guilty to that. He received before the Honorable Judge Downs 15 to do 3. Okay, so why not bring him to Grady? Excuse me. So why not, bring him to Grady? Isn't he injured from the crash? He's probably going to be injured, Sarge. That's why they've taken him to Grady detention. So probably be injured. Okay, copy that. He was the guy that was hit by the car, question mark. I don't know which one the guy he is. This is the one that AC, meaning you heard from AC Booker Higgins, officer, and them got over at the Barber Institute. That is Mr. Bean, in fact. Yeah, that's affirmed at 2836. Then I'll mark it Mr. Williams, Exhibit 204. It's file Z radio. It's 1331 through 1400 hours, so it's now 1:30 to 2 o'clock. 2820, raise 2013 and have them go over. We got the 83. That's Mr. Bean down here at Grady, and that's at 2827. So I knew he was at Grady when Miss Love was making these representations that I'm misrepresenting. But, you know, I don't find lawyers to do that. Then, Your Honor, there is a recording, and it's at 1949. We can play it for you. It's Detective Quinn and Mr. Bean. So it's 6 days later. So it's now the 17th of September, 2013. And Mr. Bean is being recorded the whole time by Detective Quinn. And Detective Quinn states as follows. Excuse me 1 second, Your Honor. At 44:56, actually,
In what, sir?
This is September 17, 2013, recorded interrogation, Detective David Quinn, now retired, with Mr. Bean, and I'll play it for you if you like, but Adrian Bean states as follows. Yes, sir, I lied to the detectives when they first came and talked to me. And I told them that's probably the lies that you're talking about. Detective Quinn then said, okay, what did you tell them? Adrian Bean, I told them Big Fred was driving. So we're sitting here. I have zero information on when Mr. Bean spoke with detectives. But I do know this. Mr. Bean told me that he spoke to detectives at the hospital. Detective Calhoun testified before the court, went down to the hospital, spoke with, it's on recording, Fred Prethrow. Fred Prethrow was asked, what happened? Who was in the car? Fred Prethrow said, DK, Adrian Bean, and me. 3 occupants, 3 occupants. It's on recording. Detective Lewis goes and speaks with DK, who is known as Mr. Walter Murphy. I have no recording. I have
No recording of whom?
Detective Lewis at the hospital, Grady Hospital, September 11, 2013, meets with Walter Murphy. And Your Honor, as my eyes roll out of my head, I'm about to show you why I do not believe the City of Atlanta Police Department at all. This is served in discovery. I will mark it Mr. Williams C and D. And then you tell me if I'm supposed to believe the allegations from the state of Georgia.
And Your Honor, while Mr. Steele is pulling that up, I am reiterating that his failure to believe or not believe is not a good faith basis for asserting facts that are not in evidence.
So let him finish and I can kind of have another conversation with y'all about it, okay?
May I approach you?
You may, sir.
For purposes of motion, I am handing the court what I was provided in discovery by the state of Georgia. I made it for today's date, Mr. Williams, Exhibit C, Ms. Colette or Charlie, and D as in Delta. And if you will see and take note, on the top, it's the City of Atlanta Department Supplemental Incident Report, narrative only, page 1 of 1 on both C and D. Your Honor, the incident report is exactly the same, 13-254-1308. The complaint name in both are left out. The date of the report is the same, 9/17/13. It says reserved, and nothing's in there. It then has a narrative section. with an affidavit. Your Honor, the first paragraph has Detective Lewis going to, the two people going to the hospital with injuries, Investigator Calhoun and myself, Investigator Lewis, went to Grady Hospital. If you remember from the testimony, Investigator Calhoun goes and meets with Mr. Plethro, 3 people in the car. Investigator Lewis goes and meets with Mr. Murphy. Investigator Calhoun recorded it. I have this report on Investigator Lewis. Next paragraph of C and D are identical, Your Honor. Once we arrived at Grady Memorial Hospital, there were 2 males being brought in for gunshot wounds. I was advised by the Grady medical personnel were not life-threatening. We could speak with them once they got stabilized. It's going to be identical. The next paragraph, Your Honor, the first 2 lines. The first line, I spoke with Walter Murphy in C, gives a date of birth, 8/9/91. He had sustained a gunshot wound to the left thigh. It's going to be identical. Then it starts, he advised that. In C as in Colette and Charlie. But in D, it says, he advised me during the. Then D is whited out. The entire part is now vacant. C goes on to say that, that the other 3 males, now there's 3 people in the car, one named Bean, drove to the laundromat on Cleveland Avenue to meet up with another male to sell an ounce of marijuana for $450, and it goes on. Your Honor, at the bottom of C, it is signed, same looking signature of Investigator Lewis, I presume, on 7, reporting officer's signature. It is also signed similar on D, Mr. Williams D. The APD number is written in on D, but it's typed in on C, and it's the same ID number, 3081. As far as Section 9, which is in the center on the bottom, it says sworn to and subscribed before me the 17th day of September 2013 in type on C. D, it's in writing. And then on the bottom, it says supervisor's signature, and a supervisor actually signed off on C, which is supposedly a complete report, as also D, which is clearly whited out. In addition to that, Your Honor, on both C and D, there is a statement at the very bottom before the signature, above the signature line, the undersigned being duly sworn upon his or her oath deposes and states that the foregoing is true, correct, complete, and legible to the best of his or her knowledge and belief. So when I sit here and I hear Ms. Love tell me how diabolical I am and how I don't have a recording or I don't have a statement or I don't have a note or a summary or a writing that Mr. Bean was interviewed at the jail, at the detention center after Ms. Love told this honorable court total misrepresentations. I don't know. I assume that she had a good faith belief because that's just what I do with lawyers. But she attacks me like I'm out of my mind when this is in the discovery. This is all, she knows this. And then I'm giving C and D, which is clearly going to come out before your court, because if the state doesn't call the investigator, I'm calling Investigator Lewis. Because this is what I would say is corruption. Because I don't see this often.
Do we know why
Right.
why one statement is incomplete and the other one is?
And why I have no recording. And why I only have this on the 17th day of September. And why Detective Calhoun's is all in recording and a report on that day. And why is it that Adrian Bean tells Detective Quinn, when I first spoke to the detectives, I lied to them about Fred Prethro driving? And why is Adrian Bean telling me, yeah, the police wanted young thug, Jeffrey Williams, whatever the words are, involved in this case? And why is it that Adrian Bean is on a jail call with his wife? It's the next day. It's September 12th of 2013. And his wife says on that jail call, the homicide investigator, it's going to be Detective Quinn, came by a second time yesterday. That's the date of the incident. And he told me that the driver, people think the driver's a woman. wearing a wig, but it's really a man. It's a boy. And Detective Quinn is giving this information. And whoever the driver is in big trouble, but if Mr. Bean is a passenger, he may not have any charges. And on that same recording, Adrian Bean is telling his wife, they gave us a story to tell. And Adrian Bean tells me with Investigator Martin that that story to tell happened at the hospital. Now, he blames it on Detective Quinn. It's also 10 years before, so maybe it's not Detective Quinn. I'm not saying it's Detective Lewis. My questions were, or some detective. But his point is, it's a detective that introduced Jeffrey Williams to this. And then you could go through the crime, which I'm going to do, the crime scene photographs. There's not room for 4 people in the back of the car. In addition, there's no shooting in that car. Like the police did it and they cleared, and I'm not saying Robert Sinnell was not justified. I am not saying that. But Robert Sinnell discharges firearm multiple times and it crashes through the very rear window on the passenger side of that 2004 Nissan. Those bullets go somewhere. Mr. Murphy is shot twice, one in the lower ankle in his right leg and one in his left leg, upper thigh, which strikes an artery. That's why there's so much blood from him. Fred Plethro is shot through the headrest. Now just imagine a 6'3" young man sitting in the ways of those bullets. They can't get around him. There is no one else in the car. And the state is blaming me for this. This is outrageous. And I can ask every single question the way I ask it, and I ask it properly. And Adrian Bean, for all that he's worth, the jury makes a determination. And what Ms. Love is trying to do is obstruct the truth from coming out, because she knows all this. That's why last time I was a fibber for telling the court that he went to Grady Hospital. When she realizes it's patently true, now I'm a fibber because no one spoke with him. And I'm just supposed to believe that these officers took him down and they had him on wraps and no one spoke with Adrian Bean. I apologize to the court. That's also a jury. Juries make those determinations. In addition to that, this case should be dismissed. This is outrageous. I'm going to do that once I get it into evidence before the court, but I'll do it now since it came up and Ms. Love is attacking me. And this evidence is wrong. I also ask continuously for all these videos. I don't get it. And then months later, I'm getting a video on the shooting at the movie theater, which I know you don't know about yet, but it's about Christmas of 2000, maybe 15. The point I'm trying to make to you, Your Honor, is this is a moving target by the state of Georgia. And no, to say that I have no good faith belief because I can't show this honorable court where these statements are, that's my point. It's Brady evidence. This is all Brady evidence. And if this happened in another forum, the state bar, I'm not doing that. I don't report people. I believe in people and lawyers. I don't know what Ms. Love is doing, but to attack me on misrepresenting to this honorable court, I have never done that. I will not do that. And I will never, ever do it to any court. That's not what we do. But I also understand my duty is to make this process rigorous, zealous, and I am going to fight for Jeffrey Williams in every lawful and ethical manner the entire time. And that includes destroying Adrian Bean's testimony and revealing the truth. In addition to that, Your Honor, the state of Georgia calls our investigator and wants to know dates and how many times we supposedly met with Adrian Bean. That is work product. That is not a statement. That is not covered in any type of work product. And this is not my witness. So when you ask the court and you never got the answer, but OCGA section 17-6-4B as in Barry, Bravo. May I approach, Your Honor?
You may, sir.
All right, this is 17, I've handed this honorable court, the Honorable Mr. Kearns and the prosecution of the Honorable Madam President, District Attorney. 1716-4B1, it's on page 3 of 5 of the copy I've given the parties. It states the reciprocal discovery, which Mr. Williams did opt into. B1 towards the center but top of the page. It states the defendant within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or as otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties or as ordered by the honorable court to inspect and copy or photograph books, papers, documents, photographs, tangible objects, audio and videotapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings and places which are within the possession, custody, or control of the defendant, and this is what I stress, and which the defendant intends to introduce as evidence in the defense's case in chief or rebuttal at trial. I am not in my case in chief. This is the state's case in chief. I'm on cross-examination. On 17-16-7, which is the other copy I've given this honorable court, and the parties, our legislature wrote, no later than 10 days prior to trial or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in the possession, custody, or control of the state or prosecution, or in the possession, custody, or control of the defendant or the defendant's counsel that relates to the subject matter concerning the testimony of the witness that the party in possession, custody, or control, and this is what I stress, Your Honor, of the statement intends to call as a witness at trial or at such post-indictment pretrial evidentiary hearing. I am not the person who intended to call as a witness at trial or any such post-indictment pretrial evidentiary hearing, Mr. Bean. The state called him. I don't have to, by law, give anything to the state that I did, and calling a person under the umbrella of the attorney-client privilege and asking to give over information is unethical. When Ms. Love asked me yesterday, I was very polite to her, but I told her, I feel like I would be contributing to your unethical and unlawful conduct. I will not speak with you about this. In addition to that, Your Honor, you heard Detective Velasquez testify that he, at times, destroys recordings. I have never heard that before. You heard Detective, who was a female, Benton, say that that is a crime. You heard a witness, Mr. I'll get the name, but he's the one who had the car from his girlfriend, say, Nava Flores, thank you, say that he made a statement to Detective Quinn, and that statement was then erased, deleted, whatever his word is in the transcript. That's what I'm dealing with. And this is all taken together. In addition, if you remember, Mr. Williams is stopped by police officer, and he testified, I don't know where the video is. It should be there. I don't have the video from anything that is helpful to Mr. Williams. Things that would gotten. I don't have the video in this instant. You would know how many people, the jurors, not you, would know how many people get out of the car. There's a video recording right there. Of course, I don't get that. So my point to this court is for Ms. Love to take me to task and say that I somehow did something untoward is beyond offensive, but I really don't care because it's, you know, I've always learned that you got to listen to who it's being given from. So I don't really care. But what I do care about is we have delayed the trial for Ms. Love. I was cross-examining Mr. Bean last time. I wanted to cross-examine him now. I have every reason. I've impeached him. He said that he did not tell me or Mr. Martin things on that recording. He did not, or he doesn't remember. I've laid the foundation. The Honorable Court wants me to lay the foundation. I laid the foundation. I intend to play the recording with him. I'm also going to play the recording with Mr. Bean and Detective Quinn. Mr. Bean was asked questions by the state of Georgia. They left out all the parts that Mr. Bean admits that he lied on jail calls to his wife. The state didn't ask him about that. I will ask him. Now I plan on playing that recording. It's about 2 hours and 30 minutes. Then I have jail calls that I'm planning to play, where Mr. Bean specifically tells his wife, and he explains it on the recording to me, they gave us a story to tell. He wants to get out of jail. He adopted, inserted Jeffrey Williams, an innocent man. I'm asking the court, under all these circumstances, to use its discretion, and I would like this court to bar this trial from going forward, because this is what I'm dealing with, and it's not only now. You are going to hear this. I know I did it earlier, but you're going to hear it over and over again. And Ms. Love continues to try to make me some sort of villain. From her opening statement and defies the court order, don't mention that I'm represented anybody, don't mention any appeal. She puts it on the screen. She asked witnesses, did the Honorable Keith Adams or I speak with a witness? That is not bias. That's what we're supposed to do. You would go crazy on me and Attorney Adams if we didn't interview all these witnesses. That's why we take these breaks. Because the state dumped on us all these witnesses in September, October. I need to interview them. I've been doing it. And now I'm being somehow told that that's a bad idea and I have to give the state all my notes and when I met with people and who I met with them with. I'm not doing it. And it's not required by any law. If you notice, the state doesn't cite any law. The state of Georgia also gave me until 2 nights ago at midnight to provide all this information. I ignored that email. The Honorable Court was on it too. I don't know if you read it, but it is obscene. Ms. Love is not my boss. I owe nothing except to the law and Mr. Williams. And that's where I am. I am so focused on the law, the court, doing it right, and my zealous advocacy for Mr. Williams. And with all this being said, I don't know how I'm standing here at 2:30 in the afternoon.
It is 3:30, that clock's up.
Okay. All right, 3:30 in the afternoon and arguing somehow that I'm doing something wrong. I did not hear an apology from District Attorney Love telling the court that I'm not being candid with the court. I don't want her apology, by the way. I wouldn't want it. I don't seek it. But I do want the Brady evidence. I believe that these exist. I believe that there is a memo, a statement, a recording. Nobody goes and talks with Mr. Bean. Why would he say that to the detective 6 days later? And say, I lied to your, whatever it is, coworker, I'm not looking at it right now. I lied to your detective, your coworker, your son. Why would he say that? And why would Detective Quinn say, yeah, all right, well, tell me what you said. What'd you lie about? Detective Quinn wasn't like, what? You were interviewed? I don't have a statement. What are you talking about? But now, of course, I'm stuck with Detective Quinn telling me, no, I don't have anything, Mr. Steele. So my point to you, Your Honor, is this is total misconduct. This is clearly misconduct. And if it's not evident, I have never, maybe the court has, but I have never seen, this is the second time. I don't know if you realize it. because it was a pretrial motion. It's the second time that statements, police officers' statements are totally wiped out or changed. It happened with a pretrial, tried to suppress some evidence. Honorable Court denied it. I asked, why did we have 2 police reports? The officer said, I have no idea.
Is that when we had the hack or something to that effect?
I can't answer that.
Yeah, but I believe that there is some, so there was some discussion at that point in time about
But
that.
this doesn't make sense to me because right at the critical point, I don't know how I got it. I mean, but it was served in discovery, so I appreciate the state doing that. But D, Mr. Williams dated today, right at the critical point of he advised me during on D, Mr. Williams D, it's blank. And then on C, as in Colette or Charlie, he advised that, so it's changed, he and 3 other males. All of a sudden, we're right there with 3 other males. I also interviewed Mr. Murphy. He said, I never said there were 3 males in there. Get the recording. But I have nothing. So now I guess Mr. Murphy's lying. So Mr. Bean's a liar, and I don't get to present the truth to the jury. Mr. Murphy, I guess, a liar, I don't get to present that to jury. All because district attorney who's employed with the Fulton County District Attorney's Office, District Attorney Love tells me I can't do it and tells this court that I'm manipulating. So I am, I'm outraged. I mean, I've never, as you know, I've never been a court, but this doesn't make sense. And to have a lawyer come up and tell you, Your Honor, how lack of candor I have when District Attorney Love knows all this. This is in her own exhibit that's introduced into evidence on radio traffic. And if she doesn't know it, then say, I don't know the case. I shouldn't be making these representations. And where is the documentation that she had on March 4th telling this honorable court that Mr. Bean never went to a hospital and went right to jail, which concerned this honorable court. And you told me, hey, this is important. You're not going to manipulate anybody. I know you're not going to do it. Figure it out. I know you don't want to play games with the court or whatever your words were. You said all that. I know you wouldn't ever do it on purpose, but I need to know, because if he didn't go to the hospital, you're not going to present it, right? And I said, I won't present it. It's true. But it's not accurate. And Ms. Love just walks away without any type of admonition to say, you got to tone it down. This is a trial. Your court called it Battle of the Titans. The Honorable Judge Tom Davis once told me trials are a collision sport. If they don't like what's coming out, that's for a jury to determine. But the rubber has met the road. I am here. I am prepared. I am focused, and I want to go forward. Well, I'd like you to declare that this case should not go forward because I don't understand how I don't have this information. And it doesn't make sense that, oh, no one got the surveillance. Are you joking? Did you see how many police officers are there? There is a recording that you heard. They were looking at the surveillance video. You heard that. Mr. Adams played that. Or the state actually played it. Mr. Adams asked them to play it. But I don't get the surveillance video from September 11, 2013. How is this all just no big deal? I think it's a big deal. And I think that this is an unfair, not you, Your Honor, this is an unfair trial to put this on Mr. Williams 10 years ago, 11 years ago, and the state is not giving me Brady evidence and now trying to thwart a cross-examination. I just, my mother would tell me that I have a lot of nerve if I raise those issues.
Okay. Anything else, sir? I'm going to make a decision as to the issue of Mr. Bean. But preliminarily, I'll admit Williams 202-203, the recorded interview of Mr. Bean and Detective Quinn, and Williams C and D under the purposes of
Your Honor, I also have...
One sec, please. In order to make a 103 determination under OCGA 24-1-103.
I also have Mr. Williams B as in Barry Bravo. And that's I know the court said you're looking at, that's an excerpt portion of the proceedings relating to a bench conference during the testimony of Adrian.
I'm gonna rely upon in fact, I'll ask Miss Weaver to attach the rough transcript as the next court exhibit in order that was prepared by her. It's a lot lengthier and full and describes what happened prior to that than our bench conference. So that'll be the next court exhibit in order.
Okay, and that next court exhibit I was referring to as B, Mr. Williams B.
Okay. I'll just ask Miss Weaver to include that as well. Okay, all right.
Your Honor, I have before for the court's consideration, State's Exhibit 1JWM. It is the defendant Jeffrey Williams list of witnesses, Your Honor. He lists 28 witnesses by name. His list of witnesses, number 29, states any and all co-defendants in the above referenced indictment, but more importantly, number 30, any and all witnesses named in the state's witness list are on defendant Jeffrey Williams' list of witnesses. Adrian Bean is a witness listed on the state's witness list. And since defendant Jeffrey Williams has listed Mr. Bean as one of the witnesses he intends to call, the state is entitled any interview of Adrian Bean and is entitled to know how many times, what interviews, what recordings defendant Williams has of interviews with Adrian Bean. That's the first thing.
But that would be in contravention of 1716-4 and 1716-7. I mean, yeah, you're right. You're entitled to them, but it's for his case in chief.
Your Honor, the 1716-7 specifically says any statements of a witness that the defendant intends to call as a witness at trial. And the defendant listed on his list of witnesses that he intends to call.
Okay, but it's not his case yet.
I understand.
And he has no burden to do that. And he may change his mind in that respect. So I'm not even going to consider that until such time as the defendant makes his case in chief. But I agree with you and I agree with Mr. Steele. It would need to be turned over at that point in time.
Your Honor, additionally, Mr. Steele failed to say to the court, point to the court. Instead, he spit out allegations and insults that were meant to, I suppose, take the place of actual evidence. There is no statement, Your Honor. He pointed to—
No statement of what?
There's no statement made by Adrian Bean at the hospital. I was wondering why he didn't play the interview that he had with Adrian Bean. So at this time, Your Honor, the state tenders for the court's consideration the 10-minute interview that Mr. Steele has.
Can I hijack off for just a second? Folks, it's about 3:40 can we, since I don't think we're going to get to our jury today, can I ask them to come back tomorrow?
The state has no objection.
Mr. Steele, anybody? Okay. Because it sounds like we haven't done anything. We're not going to, this is going to consume the rest and the residual of the afternoon in Wheeler parlance terms. All right. Sergeant Ingram, if you could just release our jurors and tell them that we will see them tomorrow. Hold up. Let me give you time. In fact, I'll do it. Just have them come out. All right, ladies and gentlemen, please be seated. All right, ladies and gentlemen of the jury, good afternoon. Okay, I got good news and I got, not so good news, all right? Which one do you want to hear first? Okay, okay, I like you all. All right. We unfortunately got bogged down with some business that we need to take up outside your presence and hearing. And of course, I told you that happens during trials. And I try and as much as I could, but I failed miserably in that attempt today. So, we're still working. So what I'd like to do is, and here's, I guess, where the good portion comes in. I'm just going to recess it for today, okay? And have you come back in the morning. If you could be here tomorrow morning for as close to 8:30 as you can. We'll start probably a little after 9 o'clock. And then we'll probably go to a little after the noontime hour, and then we will be complete for tomorrow. Does that work for you all? Okay. Any ministerial inquiry of me? Okay. Thank you again. Thank you for your patience with us. We appreciate it. And we know these kind of things happen, and I told you they would happen. And I tried as much as I can not have you waiting and waiting on us. So please accept our apologies or my apologies on behalf of everybody, okay? All right, ladies and gentlemen, unless you have any other inquiry of me, leave your notepads in the basket. Remember the admonitions I've given you. Don't discuss any of the matter that we have covered up to this point in time. Do not review any news accounts or any other recaps of what may or may not have happened in court. Of course, you can only consider what's in the four walls and presented to you in lawful form inside this courtroom. If anybody should try and talk with you about this case, remember your duty to let myself and Sergeant Ingram know immediately. Don't go by and visit any scenes. Don't go by and have any outside conversations in regards to anything you may have heard inside or outside this courtroom, okay? And of course, don't listen to any news media accounts about the trial like you've done so far. So, ladies and gentlemen, unless you have any other questions of me, I'm going to go ahead and release you for the day. I'll see you in the morning, okay? For 8:30. All right? All rise. All right, ladies and gentlemen, please be seated. Our jury has left us. You've asked for a lot today, you know that? So, you should be happy with where you are at this point in time in the afternoon. Right? Okay. Oh, and by the way, you need to have your order done to me by the 29th, since you volunteered to speak up. And yes, I will give you a comfort break. How about we take councils to 4 o'clock? Does that work for you all? Miss Hilton, since you already had a break, you need to sit down here for the next 15 minutes in timeout. Okay, but everybody else, let's just come back at 4 o'clock, okay? All right, and we'll finish up for at least this issue. All right, we're in recess until 4. that work. Mr. Harvey, can I see you for a second, please?
That one.
Investigator Jimmy Martin Jr. We represent Mr. Jeffrey Williams, also known as Young Thug. We are standing in Kroger. Look at the address. And it is approximately. Are you familiar with this Kroger? Somewhere it's on Terra Road. It's approximately 11:12 in the morning on Sunday, the 22nd day of January 2023. We're here with Mr. Adrian Bean. Mr. Bean, is your name spelled K-D-R-I-A-N-B-E-A-N? Yes, sir. And can we just have your phone number for this recording? 404-380-0730. The date of birth, please. 06/22/1979. And Mr. Bean, do we have permission to record this? 42 years old. Do we have permission to record the conversation? Yes, sir. Okay. As you know, as I just said, I represent Mr. Williams, Mr. Jeffrey Williams on file right now. Young Thug is his performing name. Jim Martin Jr. and I work together. Jim Martin Jr. is an investigator, a licensed investigator. And I just want to go over what you told us previously and make sure this is accurate. If it's not accurate, all I want, like I told you before, is the truth. That's all I want. You were in I'm not saying you were every day, but you were in a situation involving a good friend of yours, a very close person to you, named Dirty Red, with Mr. Walter Murphy and Mr. Fred Prethro, and Walter Murphy is also known as DK. I mean, it's what you told me. Is that correct? Correct. And I'm telling you the date. I'm not saying you remember, but we're talking about this the 11th day of September 2013. So September 11th, everyone knows, but it's 2013. And there's a shooting and a car that creams into a side of a laundromat. You know what I'm talking about? I'm familiar with it. Okay. Now, you were never charged with that, or you were never prosecuted for that case. Is that true?
Yes, sir. We didn't ever even go through the motions on that.
So, and what happened with your charge? It was,
the case was dismissed.
Okay. I just want to make
The
sure.
whole case was totally dismissed.
Okay. Now, I'm interested in Jeffrey Williams. Young Thug. Was he in, around, participant, giving direction, anything involved in that event that we're talking about involving Dirty Red in September 11, 2013?
No, sir. Okay. Like I explained, when, all that occurred, everything took place, they was, trying to force him in on something that he wasn't even implementing. Like I said, I'm not going to lie on the brother. You know what I mean? And, he wasn't with us. Young Thug was not in the car with us that day. I don't even know how his name really got mentioned. Maybe it was a lot of hype through the streets. Or, I might have was in confidence talking and said his name, but I ain't, him and Linda saying that he was with us. You know what I'm saying?
And when you say that they wanted him involved in the case or whatever your words were, who was they?
Detectives and other, people that was inquiring. You know what I'm saying? I don't know, discuss the neighborhood or whatever.
The police?
Yeah, police.
I mean, the authorities or whatever, the prosecutors, the police?
Yes, sir.
Okay. And I played for you a recording a short while ago, and this too. And I promise you I'll email it to you, the second one, and I will. But the one I played for you has you and your wife speaking, and at some point around the 11-minute mark, you said they gave us a story to tell. Remember hearing that?
Yes, sir.
And can you tell us what that meant?
That they was really telling us to hey, put Doug in on this right here. You know what I mean? If you don't put him on that, you could be facing a lot of time and all type of shit like that. You know what I mean?
And who is they again? I know.
At the point.
Okay. And the other prosecutors and police?
It was just really just him and it was just really him I had mainly dealt with.
Okay.
There was a few more officers that was just around, you know what I'm saying? We was in the hospital.
You're in the what?
I was in the hospital, you know what I mean, when shit happened. So it's like they pushed in and I was like, man, I'm the victim. I don't know what's going on. So,
Yeah,
as far as accident,
right. The car, they say,
we crashed.
yeah, careened over a police car and into the side of the building.
Right.
And you were driving the car.
I was the driver.
Okay.
And he said, so I said he the driver.
Yeah.
You know what I mean? So
The police wanted you to say
you had to get up. But he was done so, but not in the vehicle with us.
Did he have anything to do with it?
It had nothing to do with none of that. Can't no man, I'm 42 years old, can't no another man tell me what to do. Can't no other man make no another man tell no another man what they need. Everybody wrong.
So why did you tell the police, because I'm recording, that Jeffrey Williams was involved in this armed robbery because the police told you to say that so you get out of trouble? Is that the reason?
Yeah.
Okay. Now, you're also on another jail call, the one I'm going to send you.
Yeah, that's the one I want to hear. You know,
I'm going to send it to you. But from what you say, the reason that you would have a jail call with your wife and a friend of yours or whoever, you're going to tell us, that's because the same reason. It's just the police gave you something, a story to tell you. You're going to say it to everybody. Okay. All right. We're going to shut the recording. It's what you told us the truth because that's all I've ever asked.
that's it.
All right. Did anyone promise anything, threaten you?
Nobody probably will.
And Jimmy and I have been Investigator Martin and I have been straight with you all the way. Is that true?
Right.
And Investigator Charles missed out.
I've been working hard trying to catch up with. I work hard too. I just started working 2 jobs, so you know I'm at work working day and night. So you know,
Appreciate that.
certified flagger, certified supervisor. You know what I mean? And I was doing dishwashing at night. So you know what I mean? I'm real whoop. Be going in 23 to be going through anything that got something to do with court of law or anything like that. I'm real whoop for that.
And just because it's going to come up, you did go to prison for 3 years, got 10 to do 3.
Right.
But I know what you explained, but just explain again what truly happened. I know you took over.
I don't even know when we went into court. Me, Walsh Murphy, and I think one day we come to court and they said, case dismissed, said the victim had killed himself or something like that. So I'm like you don't got a victim.
I'm talking about your other case. The one you went to, yeah.
But that had something to do with my children. They ain't got nothing.
But your children
I
want to be fair.
What happened with my kids was I had a Polo Rock. You had a 10-year-old and a 12-year-old that was choked. One of them was punched in the stomach. It was my kids. And I went around there and held with the guy calling me by myself. And I got caught up in it, and I explained to the judge what happened, and the judge sentenced me to 10
And you caught up with the person that you killed.
Yeah, I shot both of the guys that, in the midst of
And how old are those?
The one was 28 and the other one was 31. They was shopping on a 10 and 12-year-old about their basketball goal in the neighborhood, which was my kids.
Right. So
everything that went on me, it happened with me and my kids. You know what I'm saying? It had nothing to do with none of that.
And then last thing, and I'm sorry that you went through that and your children.
Right.
YSL. Are you ever part? They're saying YSL's a criminal street gang. Are you ever part of a criminal street gang? YSL?
No, sir.
Do you know Jeffrey Williams to ever commit a crime? Ever?
No, sir.
You only know him through his music and his reputation.
Only time I ever heard of him, on the radio. You know what I mean? Through our neighborhood, you know what I'm saying? I don't got no history with him. I don't hang with him. We live in 2 different separate places.
Okay, and whatever happened, and I understand it was dismissed, but on September 11, 2013, as far as you're concerned, that had nothing to do with criminal street gang activity. Why?
No, sir.
Okay.
No, sir. I ain't initiated that. I mean, like I said, I don't got no tattoos, no name, no sign. Ain't on my body that'll make me, and around me, period.
Is it okay?
I'm a working man.
Is it okay if I turn the tape off? Unless Brian has another question.
I just gotta announce the time.
Okay, it is now 11:20 a.m.
And we're gonna, we're at the Kroger's, it's in your neighborhood, the Kroger in your neighborhood. Near,
January 22nd, 2023.
I still repeat, man, young
It's on Tower.
Young Thug was not in any vehicle with me, never gave me no permission to do no crime. I'm way over than Young Thug.
He never directed you to commit any criminal activity
No,
whatsoever.
sir.
You know him as a good person?
You know, I ain't never heard a guy do nothing crazy. You know, he take care of his neighborhood, he take care of his family. You know what I mean? You know, the street, everybody want to be against the man. You know what I'm saying? So you know how it go. You know, when you in the streets and making money, rich, doing your thing with music, you got blowing stuff. You take their name and put it on what you got going on and just be, you know, helping out. A lot of rappers, you know what I'm saying? You know, they make it be a game, but it's not a game. I'm over here doing good political stuff. You don't see me in the neighborhood, bumming around in the neighborhood. I'm in the studio. Right. Man, make it work. You know what I'm saying? Like I said, that was like 10 years ago. When they talk about me and this guy, guy just killed himself. That shit be over with, man. You know what I mean? If you want to kill this,
Not over with, but we appreciate it. All right, thank you. We're going to shut the recording off. It is now. I say, you know what? It is 11. Keeps going off the time. Let me 11:22 a.m. Cutting it off.
So, Your Honor, that is the entirety of the conversation that has been provided to us. The court heard the interaction between the defendant, Brian Steele, and Mr. Bean. Mr. Bean, when asked, I know based on the conversation we heard that there was some conversation that he and Mr. Steele had outside of this. Of course, on redirect, we can ask that question. What was told? What were you told to say? Was there anything you were told to say? But I think it's important to note at one point during his cross-examination, do you remember them explaining that they, meaning the detectives, tried to force Jeffrey Williams or Young Thug into it? Do you remember saying that? Mr. Bean said, I think that was something you said, right? So all throughout this 10-minute recording, we hear Mr. Steele leading Mr. Bean, putting words out there, Mr. Bean acquiescing to what is being said. But the only thing regarding a statement that Mr. Bean tells Brian Steele, true or false, the only thing he says about a statement that he gave anybody was that they trying to put Thug in here. And if you don't do this, you're going to be facing a lot of time and all that shit. And Brian Steele said, who is they again? And Mr. Bean said, Detective Quinn. And then Brian Steele said, no other prosecutors or police? And Adrian Bean repeats, no, it was just Detective Quinn. In the interview with Detective Quinn starts that recording before he ever even approaches Adrian Bean. And that happens on September 17th, 2013. That's 4 days after the incident occurred, long after Mr. Bean had been released from the hospital. And he was released from Grady detention around 6:30 and was not put in the jail at 12 o'clock midnight on September the 12th. The first thing you hear Detective Quinn saying is something akin to, I'm Detective Quinn, have we met? And Adrian Bean never says, yeah, remember I talked to you yesterday or day before, some other time. And Adrian Bean, in his conversation with Detective Quinn back in 2013, he says, yeah, I told them at first. And the reference that he is making based on everything that is around this conversation is that while he was on the scene, he told them someone else was driving. Mr. Steele's question to Adrian Bean, why did you tell the detective at the hospital, Grady Hospital, on September 11, 2013, that it was not you, but your dear friend driving that Nissan vehicle? That's so wrong on so many levels. Number one, he is injecting stuff, assertions to the jury that doesn't exist, manufacturing evidence. What he should have done was ask Mr. Bean whether or not he spoke with someone at the hospital. He can lead him. He can say, you spoke with the detective at the hospital, right? Because that's all that's in this interview that we have between him and Mr. Bean. You spoke with the detective at the hospital, right? And that detective was Detective Quinn, right? Well, if he says, I don't know, I don't remember, then he can confront him with the inconsistent statement, which is, didn't you tell me and Investigator Martin that you talked to Detective Quinn at the hospital? He can say yes or he can say no. And then he can play the statement that he talked to Detective Quinn at the hospital. What he cannot do is assert as if it is fact, why did you tell the detective at the hospital, Grady Hospital, on September 11, 2013, that it was not you, but your dear friend driving that Nissan vehicle? He never says that. Mr. Bean never says that in this interview with him. So Mr. Steele is sitting here conveying to the court as if he doesn't realize that he is impermissibly injecting facts that are not in evidence before this jury. Like what, Judge? Mr. Steele's been doing this twice, 3 times as long as a lot of us in this courtroom. He knows what he is doing, and it is disingenuous for him to suggest that he is innocently, impermissibly putting facts in front of the jury that don't exist. He says, when I object about that and say there are no facts and evidence, there will be no statement put into evidence, so object. The court asked Mr. Steele, did he make that statement? Mr. Steele refers to the court. He says, yes. And then the court asked to see it. Mr. Steele says, yes, sir. And didn't produce it. Even today, he hasn't given anything to the court that shows where Adrian Bean said any of these things that he's asserting that he said in his questions to him.
Well, I think he's given me these statements in terms of Williams, Charlie and Delta. And I will also want to say that he also.
And Your Honor.
Hang on. And also the radio and traffic that was played from, or at least proffered from my consideration, Williams 202 and 203, and the recorded interview of Bean and Detective Quinn. So, I mean, I think he's got some basis to ask some of these questions. That now, I would agree with you that maybe some of the questions are objectionable in terms of their form and or substance. But
Judge, the defendants exhibit 1 and 2, or C and D, or whatever he called them. Tracy Lewis's report. Literally, Your Honor, the court has Delta being the draft, the partial draft. He has sat here and literally asserted that something
Delta's
is whited out. If you compare
we don't know what happened to it.
But Your Honor, the point is that Mr. Steele is trying to use that as a basis for impermissibly injecting before this jury speculation, conjecture, and assertions as fact in his questions to Mr. Bean. If you compare the two, it is literally the first draft of the final draft. You have Tracy Lewis writing this entire statement, which is defendant Charlie, and you can see the paragraphs are literally the same. She started it on this, and just because we gave them everything is no, I mean, just he's going to exploit it, I guess, to his game, whatever way he can do it. But Judge, it's literally Charlie is the complete report. Delta is the partial report. And the only person that Tracy Lewis speaks to in this report, and in Detective Quinn's report, he references that Tracy Lewis spoke with Walter Murphy, and she made a report of her conversation. And in his report, Detective Quinn also knows that Detective Calhoun spoke with Frederick Prothro, and he made an audio recording of his conversation.
Okay, but let's focus on what Mr. Steele has a belief of. Okay, I think that he has more than kind of tendered why it is he asks these questions. Now, I think that part of your objections are valid, but I think that he is more than proffered as an advocate before this court that he had a good faith basis to ask some of this. Now, you have a disagreement as to why and how, but
And Judge, that is the only disagreement that I have. I don't care if he says, did you talk to a detective at the hospital? That's the point I'm making. I don't care if he says, did you lie? I don't care if he says, did you talk to your wife on an unrecorded line? I don't care if he does that. But what he does is says, why did you tell your wife on an unrecorded line at the hospital? So that necessarily assumes a fact that is not in evidence. He's sitting here telling you, I don't know, maybe there's a statement, I don't know, the court hasn't given it to me.
Now that I've heard a little more, I think that would be more appropriate. I would probably sustain that objection. It probably needs to be clarified.
He did it throughout, Your Honor. He did it. There's a total of 28 times where he does something like that. Literally, he says, do you remember explaining that what you were referring to is at the hospital, that the police were telling us to lie, put thug in it, when you talked to Detective Lewis?
Okay, but that's...
So when he says, do you remember a thing that there's no evidence took place, he is asserting that, one, it took place, and then asking the witness improperly in front of the jury.
Did he ever talk to Detective Lewis?
No, that's just what I'm telling you, Your Honor. And then Mr. Steele gets here and says to you all this stuff and still never shows you anything to suggest that Adrian Bean talked to Detective Lewis.
Okay. Mr. Steele, you want to respond to that? Because that's critical to me. I mean, it's critical in the sense that if there was no conversation between the two of them, then that would assume facts not in evidence. Hold on. I'm asking Mr. Steele a question now. Just hold on, Ms. Love. Okay.
Honor, on the recording that you just heard at the beginning, the first couple of minutes, and I don't have the time in front of me, it was not shown on the screen. Mr. Bean said when he spoke with the detectives or the authorities, whatever his words are, at the hospital. That's what he says.
Okay, but here's her beef. If you'd have said, who'd you talk to? And he said, I talked to the detective. Well, was it Detective Lewis? Was it Detective Quinn? Was it Detective whoever? What I think that the question assumes is he did in fact talk to Detective Lewis, and he didn't.
I don't know if that's true.
Well,
I'm not conceding that.
Well, I'm going to tell you that I haven't heard anything that would indicate that's truth.
Yeah, well,
you have a good faith basis to ask that.
You haven't heard anything of who he spoke with. That's my point.
That's the point.
But you all can't. But you two, neither one of you can proffer that.
Judge.
It's not proper, Mr. Steele.
No. Listen.
It's not. It would be a violation before me for you to put that in front of this jury.
You're not letting me
He
finish.
did.
In the September 17, 2000.
You are saying to the court that you have a belief that there is another statement out there. There's not.
How could you say that?
Because it hasn't been brought up. If it gets brought up, then we'll correct it at that point in time. But right now, I'm going to direct you not to inquire that line. You don't have a basis to do so.
Not true.
Well, go ahead and make a statement and see what happens.
Your Honor, listen.
Go ahead and make the statement in contravention to what I've just told you. And I'm telling you that you will have some problems in front of me.
I'm trying to articulate to you.
You have told me everything at this point. You have told me that there's got to be a statement. Now, if you find a statement, I will, one, apologize to you. Two, I will take corrective action. That's probably not going to be nice to anybody. But at this point, there's nothing for me to do other than if you don't have a good faith basis to do it, you can't ask the question.
Honor, listen. There is a recording between Detective Quinn and Adrian Bean where Adrian Bean says, I lied to your...
But we don't know what he lied about.
He says he lied about who he's talking about, the car. But
we still don't know whether or not he had a conversation with Detective Lewis.
And I made it clear, it's 10 years ago.
But you said you had, in your conversation with Detective Lewis, that's what you proffer.
I said, or any other detective or law enforcement. Read the transcript. I made it clear. I don't know. He doesn't remember names.
He says it was Detective Quinn. Also on the recording on Sunday, January 22, 2023, Mr. Bean is the one who said this happened in the hospital. Your Honor, I'm the one complaining about I don't have the statement. I've been asking for it. This is Brady. Clearly there was a statement made.
We don't, but we don't know if there's a statement. You're supposing there's a statement, okay? And there may be. And you know what I said? And you know what I said earlier? I said if there is Brady that's not disclosed, then that particular individual is going to have some problems with me. I told you that already. Or I have a lot of different remedies I can execute at that point in time.
There has to be. That's why I gave you.
But you can't intimate or otherwise cross over the line when you don't have the statement to back it up.
Judge, I've been robbed of the statement.
But we don't know where the statement is. If we find the statement or it comes up or in cross-examination, Quinn brings up and says, hey, happen to have a statement right here in my massive file. And if he does, then of course I will revisit this particular subject again.
I'm saying it's been deleted. It's been destroyed.
We don't know. You don't know. We don't know what happened. We don't know what happened. We had the same issue that happened earlier in this trial about a statement. We don't know whether or not it was the hack or whether or not it's intentional. Now you can make whatever hay you want out of it. I mean, and the jury can decide for what they want to give it. But you cannot ask the question in its current form. You just can't.
Your Honor, I'm not asking any questions, but you have to understand the following, please. 6 days later, Detective Quinn and Adrian Bean are on recording where Adrian Bean tells Detective Quinn, I lied.
About what?
I lied.
About what?
Who was driving the car. He gets cut off. Detective Quinn says, yeah, tell me about it. Where's that statement? That's what I've been asking for.
But that doesn't still give you the latitude at this point in time to ask that question. Now, I told you, if we find out from Quinn, and I'm telling the state that if I find out that the statement exists, there's going to be a lot of unhappy people.
Well, what if you don't find out it exists? I still am entitled to. That's my whole point.
Okay, but here's the thing. You've asked me for it. I've asked them. If it comes up later, or I find out it's sitting someplace that was in possession of the state, pursuant to case law and definition, then we'll have some problems.
I understand, but you're asking when you have to find the statement for. I'm telling you the statement was made.
It doesn't work that way, Mr. Steele. I'm sorry.
It does work that way.
No, it does not.
Yes, it does.
No, it doesn't. And you haven't presented any case law to tell me how to do that. And I'm telling you, as the judge presiding over this case, if you do that, it's misconduct.
I'm not doing anything.
I'm telling you right now.
I don't know what you're telling me. I'm not.
I am telling you, you have no good faith basis at this point in time to ask that question right now, or to intimate that.
I didn't ask any question. You are listening to District Attorney Love. I'm ready to cross-examine. I'm going to play the recording you just heard. This gentleman tells me on recording that he was at the hospital speaking with law enforcement. I want that. It is backed up because on recording, 6 days after the crash into that side of the building, Your Honor, Detective Quinn and Mr. Bean are talking about the statement that Mr. Bean made prior. I don't have it. And when the court asked me, well, you got to find it, or if I find it, it wasn't given over.
Then we'll have some problems. Then we'll have some issues.
I have some issues now. I've been begging for it. The state's supposed to give this.
Let me ask, hold on, Mr. Okay, stop for a second. Ms. Love, have you inquired of Detective Quinn where this other statement may be?
Judge, that's just it. Mr. Steele is literally manufacturing evidence. There is no other statement. I have asked whether or not there was a statement. I asked Tracy Lewis at the hospital. Let me be real clear, because he keeps conflating stuff. Adrian Bean never told Detective Quinn that he made a statement at the hospital. I have his transcript.
Okay, but we don't know where he made the statement, and also he's lied. So we don't know what he lied about either.
Your Honor, to be very clear, there's no statement. I have asked Detective Lewis. They can ask Detective Lewis. She never talked to him. Okay. Detective Quinn, who is the only person, it's not just police, the only person Adrian Bean asserts to Brian Steele in this recording that he gave us, this 10-minute recording, he said, I spoke to Detective Quinn. It's obvious that he didn't speak to Detective Quinn at the hospital because the first time he met Detective Quinn was September 17th when he pulls him in for the interview. Literally, Mr. Steele is manufacturing something. So when the court is even asking me, okay, do you know where this statement is? Assuming that there's not a statement. There is no statement. There's no evidence. That's the problem with Mr. Steele asking questions the way that he asked them. He is assuming facts that are not in evidence. And he is usurping the jury's province and their ability to discern and weigh evidence because he is injecting assertions into his questions about things that don't exist. Similarly, he says, do you recall explaining that you made calls from the Fulton County Jail that you knew were being recorded to support your lie to the police that Jeffrey was involved on September 11, 2013? That's what he asked the witness. You heard the interview. He doesn't say that anywhere in that interview. This is the kind of manufactured evidence Mr. Steele keeps putting in front of the jury. He never said that during the interview, yet that's the question. That's the question Mr. Steele asked Adrian Bean on the stand. Nothing like that ever happened. And during his cross-examination of Adrian Bean, the cross-examination is replete with examples just like that. There is no statement. He can't sit there and say there has to be a statement and then ask the question as if there is one, because that's improperly asserting to the jury something that isn't factual. There's no evidence of it. So to answer the court's question, of course we have asked who spoke to whom. Did Tracy Lewis, did you speak to Adrian Bean? Tracy Lewis, I talked to Walter Murphy and I put it in my report. I made a report of that. Calhoun, did you talk to Adrian Bean? I talked to Frederick Prothro. Here's my recording of that. Detective Quinn, and then this idea of destruction of evidence, that is the fallacy that is getting thrown around. That's the problem with asserting facts not in evidence. That's the problem with them being allowed to ask those kind of questions. Do you destroy evidence? Nobody has said anyone destroyed any evidence. Eduardo Navarro Flores said he heard that Detective Quinn had erased the interview. Well, then why all throughout Detective Quinn's report does he refer to the lie that Eduardo told in the first place? How is that destroying evidence? But they're trying to create a narrative for the jury of things that don't exist, a narrative that somehow the state destroys evidence. There's been no evidence, no suggestion that the state has destroyed any evidence, but they're going to ask it a million times. So that's what Mr. Steele is doing with this whole statement at the hospital. He's going to ask it a million times. So the jury's sitting there going, well, where is it? And then in the end, $100 says that he gets up there and says, they destroyed the statement from the hospital, knowing he has no evidence that one even exists. With Detective Lewis, and certainly not Detective Quinn, who is the only person Adrian Bean tells Mr. Steele, at least in the portion of the recorded interview he gave me. I don't know what else he told. I don't know what Mr. Steele told Adrian Bean. But it's obvious that he's leading him through the interview that the court heard. And even being led, Adrian Bean does not let up on his assertion about Detective Quinn. Mr. Steele tries to get him to change it. You mean somebody else, other police, no, just Detective Quinn. So this idea that he has a right to ask questions that assume things that are not in evidence, that he has not put in evidence, that he cannot expect to be put in evidence is ludicrous. And to assert that the state is trying to hide something because he wants to taint the jury's mind, taint the fact finders with falsehoods, and somehow, I guess that's the way he wins cases. I don't know. But, Your Honor, I'm flabbergasted. The number of times he asked Adrian Bean questions that assumed facts that are not in evidence is just staggering. It's just staggering. I'm simply asking that Mr. Steele be precluded from asking those kind of questions. And Your Honor, I'm asking that any reference to statements made at the hospital in the manner that he has asked them, that assume that there was one, be stricken. And that the court instructs the jury that there is no evidence of any statement made at the hospital to a Detective Lewis. And then let them weigh whether or not a statement was given to Detective Quinn. But that's not the question that Mr. Steele asked.
Counsel, I've pondered the issue. What I'm going to do is, the questions that have been asked so far about the hospital, I believe those would be presuming facts, not evidence. There are some questions that Mr. Steele has asked on his interview that would be appropriate and are appropriate. But in terms of the hospital questions thus far, those need to be clarified in front of our jury at this point. Excuse me?
What clarification?
No, meaning that I'm going to strike them from the record at this point in time. They can be, but until there's a basis for me to go ahead and consider them.
Judge, I am still on cross-examination. This man tells me.
The state's made an objection. The objection they've made continually is assuming facts not in evidence. They're not in those facts aren't in evidence.
Judge, it's on recording. Mr. Bean said it. You just heard. I know you only heard it one time. We can play it again. He said this happened at the hospital. You are striking. You are going to be commenting on the evidence. You are going to be doing 17-857. This is for the jury to determine. This is what he told me on that record. It's on recording. He said this happened at the hospital. Talking about when he spoke to the detective.
He said that, or that was his question upon you asking it?
I've never mentioned a hospital. If you don't mind, just listen to it again. It's like the first 2 or 3 minutes.
I'll listen to it again. Let me hear it again.
Yes, Your Honor. And while we're pulling that up.
Okay, I got it on. Go ahead. Go ahead.
This is Brian Steele. I'm giving you an investigating Jimmy Martin Jr. We represent Mr. Jeffrey Williams, also known as Young Thug. We're standing in Kroger. Look at the address. And it is approximately.
Are you familiar with this Kroger? Oh, yes, on Terra Road.
It's approximately 11:12 morning on Sunday, the 22nd day of January 2023. We're here with Mr. Adrian Bean. Mr. Bean, is your name spelled K-D-R-I-A-N-B-E-A-N?
Yes, sir.
And can we just have your phone number for the recording?
404-380-0730. The date of birth, please. 06-20-1979.
And Mr. Bean, do we have permission to record this?
42 years old.
Do we have permission to record the conversation?
Yes, sir.
Okay. As you know, as I just said, I represent Mr. Williams, Mr. Jeffrey Williams on trial right now. Young Thug is his performing name. Jimmy Martin Jr. and I work together. Jimmy Martin Jr. is an investigator, a licensed investigator. And I just want to go over what you told us previously and make sure this is accurate. If it is not accurate, all I want, like I told you before, is the truth. That's all I want. You were in I'm not saying you were every day, but you were in a situation involving a good friend of yours, a very close person to you, named Dirty Red, with Mr. Walter Murphy and Mr. Fred Prethrow, and Walter Murphy is also known as DK. I mean, it's what you told me. Is that correct?
Correct.
And I'm telling you the date. I'm not saying you remember, but we're talking about it's the 11th day of September 2013. So September 11th, everyone knows, but it's 2013. And there's a shooting and a car that creeps into a side of a laundromat. You know what I'm talking about?
I'm familiar with it.
Okay. Now, you were never charged with that, or you were never prosecuted for that case. Is that true?
Yes, sir. We didn't ever even go through the motions on that. So,
and what happened with your charge? It was,
the case was dismissed.
Okay. I just want to make
The
sure.
whole case was totally dismissed.
Okay. Now, I'm interested in Jeffrey Williams, Young Thug. Was he in, around, participant, giving direction, anything involved in that event that we're talking about involving Dirty Red in September 11, 2013?
No, sir. Okay. Like I explained, when, all that occurred, everything took place, they was, trying to force him in on something that he wasn't even in. Like I said, I'm not going to lie on the brother. You know what I mean? And, he wasn't with us. Young Thug was not in the car with us that day. I don't even know how his name really got mentioned. Maybe it was a lot of hype through the streets. Or, I might have was in confidence talking and said his name, but I ain't, him and Linda saying that he was with us. You know what I'm saying?
And when you say that they wanted him involved in the case or whatever your words were, who is they?
Detectives and other, people that was inquiring, you know what I'm saying? I don't know, discuss the neighborhood or whatever.
The police?
Yeah, police.
The authorities or whatever, the prosecutors, the police?
Yes, sir.
Okay. And I played for you a recording a short while ago, and this too. And I promise you I'll email it to you, the second one, and I will. But the one I played for you has you and your wife speaking, and at some point around the 11-minute mark, you said they gave us a story to tell. Remember hearing that?
Yes, sir.
And can you tell us what that meant?
That they was really telling us to hey, put Thug in on this right here. You know what I mean? If you don't put him on that, you could be facing a lot of time and all type of shit like that. You know what I mean?
And who is they again? I know. Okay. And there are other prosecutors and police.
It was just really just him, and it was just really him I had mainly dealt with.
Okay.
There was a few more officers that was just around. You know what I'm saying? But we was in the hospital.
You're in the what?
I was in the hospital.
Stop. All right, run it back, please.
It's gonna be about 4 minutes.
All right, let me hear it.
It was just really him I had mainly dealt with.
Okay.
There was a few more officers that was just around. You know what I'm saying? But we was in the hospital.
Stop.
You're in the what?
I was in the hospital.
Stop. All right, Mr. Bean says we were in the hospital.
Yes, Your Honor, he says that we were in the hospital, but he does not say that he was, that he gave any statement to Detective Lewis at the hospital.
But that goes to weight. I mean, that goes to weight and sufficiency and what the jury wants to believe or don't believe. I mean, it's clear from the state, it's clear now from listening to the tape again that Mr. Steele, that was not a production or a product of Mr. Steele's questioning. It was the witnesses saying, hey,
Judge,
we was at the hospital.
It was after that, because Mr. Bean, when he's talking, he's saying, we were in the hospital, I was the victim. That's what he's, but if the court will just listen to.
Okay, give me another 15 seconds.
You know what I mean? When shit happened. So it's like they push in and I was up there. I'm the victim. I don't know what's going on. So,
Yeah,
as far as accident.
Right. The car, they say.
We crashed.
Yeah, careened over a police car and into the side of the building. Right. And you were driving the car.
I was the driver.
Okay.
And they even said, so I say he the driver.
Yeah.
You know what I mean? So
The police want you to say
but
that's what he
done so was not in the vehicle with us.
Did he have anything to do with it?
It had nothing to do with all of that. Can't no man, I'm 42 years old, can't no other man tell me what to do. Can't no other man make no other man tell no other man what they need. Everybody wrong.
So why did you tell the police, because I'm recording that Jeffrey Williams was involved in this armed robbery because the police told you to say that so you get out of trouble? Is that the reason?
Yeah.
Okay. Now you're also on another show called the one I'm going to send you.
That's the one I want to hear. You know,
I'm going to send it to you. But for what you say, the reason you would have.
And so, Your Honor, when Mr. Steele says, do you remember the detective asking you questions about the incident involving the armed robbery of Mr. Dotson and almost killing police officer Roberson L. and striking the other police officers, and careening over the embankment into the wall and fleeing? Do you remember that? He says, no, sir. Then the question, do you remember telling that detective, specifically Detective Lewis, at that time, there were 3 people in the Nissan red Altima vehicle? That's nowhere in this statement. What Mr. Bean is doing at the point that the court just heard, he's saying one thing, and then he's saying, we were in the hospital over there. We were like victims. We were laying there.
Okay, but he's got a good faith basis because he's got a couple of different sources. He's got this interview. He's got the, let me get to it again. Hold on one second. He's got Williams 203, which is the radio traffic. He's got Williams 202, which is radio traffic. And he's got the interview of him and Detective Quinn, Williams C and D. So so if he's got all those things, Ms. Love, he's got a good faith basis to ask those particular, because they're different source documents, but it doesn't take away from his ability to ask those questions because they are in fact things that elements or not elements, but information he has that he can test.
Your Honor, what I'm saying is, in order to say something like, do you remember telling Detective Lewis at the time there were 3 people in the Nissan red vehicle, that when he says, do you remember, it's assuming that happened.
Well,
he hasn't shown that it happened, he hasn't played anything, he hasn't laid a foundation for impeachment with that, he has nothing to say that happened. So he can't come back and show evidence of it. He's just saying it, and there's no evidence of it. He can argue it at the end, but he cannot put questions on a witness information when he says the jail call. This is the killer. When he says, the part that the court just heard, I played you a recording a while ago. I promise you I'll email you the second one. The one I played for you has you and your wife speaking at some point around the 11-minute mark. They gave us a story to tell. What does that mean? And then Mr. Bean says, I don't know again what they talked about off recording. It's like they said put thug in there. If you listen to this recording that they're talking about, Mr. Bean, and it is clear as day, Mr. Bean is chuckling with his wife over the fact that Walter Murphy and he said to the police that they're the victims. And that's the story. He said, I'm glad them boys kept it 100. I'm glad they kept it solid because they gave us a story to tell. Both Walter Murphy at the hospital said, we were getting robbed. In this jail call, Mr. Bean to his wife says, I told him, we were the ones getting robbed. That's what he's saying, and it's disingenuous for him to sit here and say, who told you? What did they mean? Was it the prosecutors, the police? Who told you that? Detective Quinn. No other prosecutors or police? No, Detective Quinn. And then when he says, we were in the hospital. I was in the hospital when that shit happened. We were the victim. The court heard him say it. Adrian Bean talks like this, and I would ask that the court allow us to enter the jail call that he's talking about so that the court has context to understand why it is so offensive that Mr. Steele is arguing that he gets to suggest to the jury things happened that didn't really happen in the form of his questions to Adrian Bean. So when he's saying, hey, they're telling us to lie, and he's saying, that's, what do you mean? They're saying put thug in there. Well, what did you mean when you said they gave us a story to tell? Mr. Steele knows what they meant because he says it in the jail call. It's clear. So we can play that for the court. I can point to all of the times that Mr. Steele impermissibly asked questions that assume facts that are not in evidence. He's saying, do you remember stating that the driver was not you? There's nowhere in here that he says that the driver wasn't him. Literally. We just heard it. There's nowhere in here that says that. Now, if he asks this witness, you were the driver, weren't you? And at first you said you weren't the driver, weren't you? And then he says, well, didn't you say to X on this date at this time that you weren't the driver? Because guess what? He can then put forth X and show where he's lying. Right now, he's putting questions on the witness about things that don't exist. So there's no way anybody can test the witness's knowledge on them because they don't exist. That's all that I'm saying, Judge. And that's what I'm asking that the court preclude the defendant from doing from here on out. And I will go through and present to the court. I will literally highlight all of the times that Mr. Steele asked those kind of questions. Do you remember? Why did you tell them this? There's nothing in the record where he told them anything. There's no evidence that has been presented. And Mr. Steele knew what he was doing. He intentionally didn't do it the right way and simply say, you said X, Y, Z. Or this happened, didn't it? I don't remember. But didn't you say X, Y, Z on this date? Instead, he just jumps right to, why'd you lie to the police? Those things are not proper. There's a way to do things, and he has not done them the proper way because he wants to put in the jury's mind facts that don't exist. And that is not the way a trial is done. It's not the way to get at the truth, by lying to the jury through your questions to a witness. And that's what he's done.
Okay. All right. Anything further, Mr. Steele?
I have absolutely nothing to say unless the court wants me to say something. It's just a continuation of the rants of VA love.
And Your Honor,
I didn't ask anybody to laugh in the gallery, okay? This is a courtroom, not some entertainment forum for you. Yes.
The insults again, if they're going to be called rants, I think we should recognize what we're doing when we stand up and go on and on with hysterics, as Mr. Steele has done. I'd ask that he be precluded from slinging insults as well.
All right. Well, both of you took professional responsibility when you were in law school, and that's not the way that we treat each other as professional colleagues. So I'll just leave you with that. All right.
I do one thing, and I didn't realize you're leaving.
No, I'm going to let I think I've been asked to take a comfort break, so I'm going to let everybody take comfort, and then
I'll figure out what to do for the rest of the time, okay? So we're gonna take a comfort break first. We'll be in recess.
song right here as you sit right now that talks about the defendant Williams being truly humble under God?
I will rule the objection.
A number of songs on the last album, Pump. I ain't what the song name. Oh, Dropping Jewels. He talked about God a lot in that one.
Okay. Please tell the jury what part of that song talks about the defendant being truly humble under God.
So in the beginning, he said, dang, show me why I'm living, why am I remaining here? I know he wasn't talking about nobody else but God.
Oh, but did he say the word God?
You right.
I didn't say anything. I asked a question.
I knew what he was referring to
No,
because can't nobody else show you why you living.
My question,
No.
what are you answering me?
Did he say God? But I knew that he was referring to God.
So, can you think of a single song where the defendant Williams raps that he is truly humble under God?
Not under these circumstances.
So you cannot right now?
No.
Okay. You were also asked on cross-examination quite a bit about this plea agreement that you signed back in 2022. Do you recall being asked those questions by Mr. Steele?